Hello, everyone. Welcome back to SEC Roundup. My name is Tom Zuccaro, and with me, as always, is Nick Morgan. Hi, Nick.
Good morning, Tom.
We are honored today to have a very special guest, Paul Atkins, the CEO and founder of Potomac Global Partners, but also a former commissioner of the Securities and Exchange Commission from 2002 through 2008. Commissioner, thanks for joining us.
Oh, thank you. Thanks for having me.
We're going to talk about a rather controversial subject, and that is the SEC wading into the social and social politics with its proposed ESG rule. About a year ago, the Commission proposed disclosures for ESG by public companies. The rule still hasn't been adopted yet, but there's rumors that it may be adopted later this year. Nick, do you want to just update us on the status of the proposed ESG rule?
Yeah, so for those who don't know, the proposed rule deals with public company disclosure around climate issues. And the initial proposal was over 400 pages long, as you said, back in March of last year. The public comment period has generated, I think last I saw, something over 14,000 comments. And that's a lot of comments. And it's not surprising, given that this would, if finalized in its current form, increase the amount of disclosure on public companies in this subject matter, by a lot. So it's a potentially very burdensome rule, and so there's been a lot of pushback, a lot of delay in finalizing the rule, so that the SEC staff can consider the public comments and potentially modify the proposed rule in one direction or another. So we don't know where it's going to come out, but one thing is for sure, we're probably going to end up in litigation over this rule. Recently, we've seen environmental groups, Sierra Club being one, reportedly considering litigation options if the rule gets reduced from its current form, and other groups have suggested litigation might be an option, and so we're here to talk with Commissioner Atkins about that subject.
Commissioner, we'd love to hear your perspective as a former SEC commissioner on the rule. You wrote an op-ed for the Wall Street Journal last year saying that the rule might not survive court challenge. Can you expand on that or tell us what your views are today, given that we're a year later and the rule is still in its preliminary stage?
Sure. No, happy to chat about that. I don't want to have people be too sanguine about, what the significance of this rule and the potential, ramifications if it be adopted in its current form, because even in the proposal, the economic analysis, the estimate by the SEC itself, which usually tends to be, let's say, rather conservative, is that it will double the cost of disclosure for annual reports for public companies, basically across the board, whether or not they're involved in things that normally affect, the environment, like think of energy companies or whatever. But this would be up and down the line, especially because of the broad scope of the proposed rule and its invasion into Reg SX, for example, without really involving FASB, and which, of course, the SEC can do what it wants to. But then also, this really expansive reading of the Commission's authority, and then also with respect to, I think it's evisceration potentially of the whole standard of materiality and how the SEC has approached that, for the past, 80 years or so, whatever. So I think those are pretty, monumental types of changes that this one rulemaking is heralding. So it is very serious. And so the article that you reference was in the journal, Wall Street Journal, last year. So a colleague of mine, Paul Ray, and I looked at it and looked at the proposal, and then this was in the wake of the articulation of the major questions doctrine that the Supreme Court came out with in West Virginia versus EPA. So the Environmental Protection Agency had proposed some revisions to its approach to implementation of rules around the Clean Power Plan that they have in the Clean Air Act. And so they, in the Supreme Court's words, they found some unheralded or previously unknown authority to expand their jurisdiction into areas that the court said that, they historically didn't go. So basically, they were looking to, set standards for the power grid, the national power grid as a whole, rather than, as they had been doing, set standards for individual power plants. And so that's the, they were sort of taking advantage of some vague language of, long extant statute, but obviously kind of rarely used. And one could look at that language as being kind of a gap filler in the statute. So, and then conspicuously, Congress had declined, actually, not failed, but had declined to enact standards in, the direction of where the EPA was going. So it called into question, whether or not Congress would have intended to do that at the very beginning if later on they had, declined to make those changes. So it's similar to, what the arguments could be with respect to this particular, climate disclosure proposal. So whereas, the EPA was electric generation versus electric transmission, and then the SEC is teeing up a shift of capital to, supposedly greener industries, and looking at, what they is not necessarily what a reasonable investor, a normal reasonable investor, would view as something material to the to the decision that the investor would make to buy or sell the stock as a reasonable investor, not as someone who has a special bent on investing or a particular interest in a particular way, like want to invest in quote unquote ESG stocks or whatever. So the departure from that standard that the Supreme Court itself articulated back in TSC Industries versus Northway in 1976, Thurgood Marshall wrote the opinion for the court, where he, basically they were tackling this issue like, so what should a company disclose? And so the articulation was basically information that is material. This had to do with a vote for or against a merger for a company. So it would be, it would be information that would be material and important for that investor to know in order to cast the vote for or against that merger. So here, this is the breadth of the amount of information that the SEC is asking for. Is pretty breathtaking, down to like the zip codes of where a power plant is located and things like that, and real minutia. So back, I worked for Richard Breeden back in the early 90s, and then for Arthur Levitt. And I remember, Linda Quinn, who was the director of corporation finance, and then her successors would be very attentive to, proposing rulemaking, for example, for executive compensation and whatnot. How do we make the pitch that this is material to the reasonable investor? And so here, by statements of, former commissioner who's no longer there when this came out, when she was acting chairman and whatnot, it's basically they've thrown out the whole idea of materiality that, well, some folks have said, well, this is inherently material. So however they arrive at that, or others have said that the SEC has, quote, plenary authority, unquote, to decide what's material or not. I think the Supreme Court would beg to differ on that, and by Thurgood Marshall's writing and concern about information overload, which other commissioners and SEC chairmen have been worrying about. Mary Jo White, for example, just recently in the last few years articulated that concern, and in other matters, not on this, of course. So anyway, so that my fear is that if you have basically a standard like that that's so malleable, then it becomes what any three people at any particular time on the commission decides is material. Then it becomes even very much politicized, potentially, which I would argue this particular proposal is. So then if you have no standard at all, how do courts even handle, if we're looking at 10b-5 cases, which ultimately you have to look at Section 10b and obviously others of the Securities Act and Exchange Act and whatnot. When the SEC is bringing enforcement actions, it has to look at those. So what's material, and how does one decide what the fine should be, if there be a fine or settlement or whatever? How does the court then look at that, or a jury, if you have basically no standard? And if it comes down, you got the wrong zip code, so maybe that threw off somebody. Well, had I known that that plant was in Manhattan and that it could have been a new 3 Mile Island, then maybe I wouldn't have bought the stock. I mean, so things like that. I mean, maybe you can make that case that that's material, but it's at some point, people have to have some sort of surety, or else our whole system will break down, and then it becomes truly a jungle out there as far as what should we do, how encyclopedic should these disclosures be, and even now. So when I was a commissioner, we put out the new rule for risk disclosures for 10Ks, item 1A. And the idea was to have management just talk in plain English and apprise shareholders of what the real risks are to the company, and not with a lot of boilerplate or whatnot. Well, of course, the US being what it is, and the tort system, and as you lawyers do, how that goes. So it becomes now that some of the estimates are, item 1A takes up almost 17%, I think, is one study I saw of the number of pages, typical disclosure document. So that's not what we had imagined, I think, fair to say at the beginning. So anyway, so you see how these things grow. I don't want to belabor the point, but anyway, but there's a lot to unpack in this rule.
Well, that's terrific, Commissioner. Thank you so much on your insights, and we'll come back and visit again once the final rule is issued, if it is issued.
We'll see. Yeah, and it could change. I mean, there are lots of permutations here to this whole thing, so we'll see.
Well, thank you so much for coming on the show, Commissioner Nick. Thank you, and we'll see everybody at the next SEC Roundup.
Thank you.